Postings to the internet. Hey, what happens if they're not true? What happens if they're actually lies? What happens if they're defamation, if they hurt somebody's reputation? Well, that takes us to this week's case. It involves a real woman, an attorney in the San Francisco Bay Area, Dawn Hassel. She was representing a woman, Ava Bird. Ava and Dawn weren't getting along real well. They separated company, and then Ava posted a very defamatory review on Yelp. Dawn, not happy with this, sued Ava, said, you have got to pay me for the damages I've suffered as a result of the defamation that you've inflicted upon me, and you've got to take down that review. Case went to trial, and at trial, the judge found in favor of Dawn, said, you're right. Ava, you need to pay that damages here in excess of $500,000, and you need to take that posting down. And if you don't, then Yelp needs to take the posting down. Well, guess what? Suddenly up jumps Yelp. Yelp says, hey, wait a second, we weren't a party to this case. Now we're going to appeal it since the order is directed to us. Case wound up before the California Supreme Court. And up there, the court took a look at this. And Yelp was arguing, we're not a party to this, and in addition, we are protected by the Communications Decency Act that was passed by the U.S. Congress. And that found that internet providers would not be responsible for defamation. Therefore, we don't have to take down the posting that's up there. Well, the Supreme Court of California looked at this, considered this, and they said, in this instance, we find that Dawn really made an end run around the federal statute by virtue of the fact she did not sue Yelp, and yet Yelp is being ordered to take down that posting. And we find in this instance that, in fact, the Communications Decency Act applies, and Yelp does not have to take down the posting. So at the end of the case, Dawn has a verdict in excess of $500,000, and the defamatory material is still up there, Now, in the old days, when a newspaper would defame someone and they were found responsible for that, they would many times publish and be ordered to publish a retraction, and the case would be over, and everybody would know that the information was false. But now, in this current environment, we see this material that is wrong, that's a lie, that's factually unbased, is still up there, still defaming the person who was defamed. There are many who say this was not a very good decision. It was a very close decision of 4-3, but they are saying, others, commentators are saying, other courts may view this differently. And some are saying Congress needs to take another look at the law and provide that even though the internet provider, whether it's Yelp or Google or somebody else, would not be responsible for defamation, they need to take down the defamatory material when a court of law finds it is defamatory. But right now, they don't have to do that. And right now, we're bringing into this, as we bring in you cases every week. My name's David Allen.